Freedom of speech, a core American value, but now has become one of the most controversial and contentious topics, especially as it relates to cancel culture. But even through cancel culture, it's hostile toward freedom of speech. It is also the exercise of freedom of speech in saying that that speech should be censored for this preferred speech dictated by society or the cancel culture proponents or whoever it may be at the moment. Furthermore, the thing about cancel culture is that it's people policing people. It is not the government intervening. The society becomes the judge and the jury as to what can be said publicly and what will be tolerated by society. Is this a good thing? I'm not sure. But we don't want a society where people can go around insulting one another. It's not good for society, nor humanity, nor our social fabric. To be clear, cancel culture doesn't violate the First Amendment because the First Amendment only protects against the government's punishment of speech. It does not apply toward how private citizens and individuals act toward one another, but it impacts something the First Amendment is meant to protect: freedom of expression. If a fear of being canceled causes people to self-centered, that harms the public discourse. Keep this in mind as we discuss the White Lives Matter trademark. For those who are unaware, the artist formerly known as Kanye West, or who goes by Ye now, he spawned controversy by wearing a White Lives Matter shirt to a fashion show last month. The slogan's widely perceived as being a racist rebuttal to the Black Lives Matter movement. The Black Lives Matter movement is a response to police killings of Black people. And when we keep this in mind, we must also note that the Black Lives Matter movement is a decree against police brutality and racism. It's totally separate from the BLM organization, which has become this sordid organization associated with exploitation and stealing millions of dollars. The movement is totally distinct from the organization. So for those who are unaware, Ramses and Quinton were two hosts of this weekly racial justice radio show called Civic Cipher, became the legal owners of the controversial White Lives Matter slogan, which has caused such civic unrest and outrage over the last 2 years and once again the last month. Now, it started with an anonymous listener of the Civic Cipher who filed the trademark the same day Kanye West wore the shirt with an image of Pope John Paul II on the front with the words of White Lives Matter on it. The person purchased it or filed for the application and then transferred the ownership to the radio host. Now, has gone on record saying that anyone who attempts to print merchandise and usurp the rights of the hosts will feel the wrath of their attorneys, that they would sue them. And the partners have made it clear that the trademark is not for sale, that they don't attempt to sell it, only if someone offered them the sum of $1 billion, that they would be interested, in which case they would perhaps go through with the transaction and take the funds to help organizations combat racism and uplift the Black community. So they do have a price of selling it. They also explain that they don't anticipate anyone paying that much for the trademark. Instead, at this moment, the two radio hosts don't have any intention of using the White Lives Matter slogan. In essence, they want to prevent the dissemination of the words by keeping the ownership of the trademark. They aim to prevent Kanye West and other groups of people who want to profit off this slogan by placing it on merchandise, memorabilia, t-shirts, whatever it is. So they want to own the trademark in order to limit or censor anyone else being able to use the mark. However, it's not that simple, even though it's been presented in a way that they own it. They don't have the trademark yet. They have a trademark pending. They do not have any legal rights as of date. They don't have a bona fide trademark, and until they do, they would be hard pressed to show that they have the legitimate right to prevent anyone else from printing merchandise and products with this slogan. Ramses and Quinton may well send cease and desist letters to anyone, sellers of the White Lives Matter, but that doesn't mean that they have the legal power and authority to prevent the dissemination, because again, the mark is still pending. And based on precedent, legal precedent, it will be difficult for them to even enforce this right. Now I'll explain why. This is because the US trademark law isn't designed to police or limit messages, even if those messages are viewed as lewd, scandalous, and insulting to the sensibilities of a reasonable person. The trademarks or the trademark office explicit purpose is to prevent consumer confusion among products and brands. So in 2019, the US Supreme Court, the highest court in the land, mind you, said owners of vulgar and lewd products and names can get federal trademark protection. This ruling threw out a centuries-old restriction that prohibited trademark of lewd and scandalous slogans and phrases. The court reasoned that to curtail lewd speech violates constitutional free speech. In this case, in 2019, the creators of a clothing line known as FUCT, although offensive, the court said they still deserve trademark protection. And we don't want to censor scandalous or disagreeable speech just because we don't like it as a society. So let's look at this comparing to the White Lives Matter. The duo have a pending trademark, as I've explained before. Now, according to the USPTO's database, an examiner will need to review the application to ensure the registry isn't confusingly similar to any other registered marks or pending applications covering similar products, and that it functions as a trademark in the examples of use provided by the applicant. But a pending application is legally useless if there aren't actually trademark rights. That is, if the mark hasn't been used in commerce, which they do not have because there's no history of them using the mark, creating a brand associating with the mark. Therefore, providing a precedent that the mark is used in commerce will be difficult. Also, they will have to show that their mark is distinguishable from other marks, and that their mark, trademarking it, is to prevent the confusion with other marks. So even if Ward and Ja decide to sell White Lives Matter merchandise in a bid to establish use, they still might not be able to enforce it or to secure registration. Because often when phrases achieve a form of viral status, people rush to try and register a trademark so that they can own it. But that's not what trademarks are for. Fundamentally, they are for avoiding consumer confusion, not brand protection, not saying this is mine, therefore others can't use it. The purpose of trademark is to distinguish and protect consumers from buying something mistakenly that belongs to another product. So let's think about the first White Lives Matter trademarks that began back in 2016. This dude was not the first. Now, these marks were abandoned after initial refusal for exactly the same reason I explained earlier. The examiner said that the submitted application purported mark was merely a decorative and ornamental feature of the applicant's clothing, and thus does not function as a trademark to indicate the source as compared to other brands. Furthermore, it would be challenging for them to say, we want to avoid consumer confusion, which is why they need the trademark, because what's the consumer confusion? There's no competition with the mark, but rather the mark is a message the wearer wants to express. So unless consumers believe that White Lives Matter shirts were made by one particular company, and to separate it from other companies then it's likely that the trademark office will block this application. Now think of Nike, one of the most famous brands out there. Now if you saw a shirt with the Nike swoosh on it in the store, you probably think it was made by Nike. And others who would try to sell a shirt with swoosh on it would likely to cause consumer confusion because Nike has the brand identity. The very thing trademark protects are designed to prevent their brand identity. Now compare this with White Lives Matter. Again, there's no association with that brand. And so to try and trademark it would be useless. And which is why it would be denied. Because instead, it's not about a brand, it's about censoring speech. But do we want speech censored? Or is this a society that censors speech heading toward tyranny? I don't know the answers, but let's have a healthy debate in the comment section. Let me know what you think. Now, as we discuss White Lives Matter, I'm sure everyone must be thinking about Black Lives Matter. Has that been trademarked? Guess what? A recent search of the USPTO's database revealed that there are 77 pending or dead applications for trademark that include the phrase Black Lives Matter. Now, since the murder of George Floyd in late May 2020, over 50 new applications were filed for the marks. Hand sanitizer, Black Lives Matter movement, Black Lives Matter Moscato, you name it, there was a Black Lives Matter attached to it. Now, this wave of Black Lives Matter related trademark applications in 2020 is remarkable, given that the USPTO previously articulated position regarding the registrability of trademarks using the phrase, all of which were denied. So previous to this whole new set of applications, a lot were denied 2 years before. The USPTO rejected 6 applications containing the phrase Black Lives Matter that were filed by originators of the movement, Alicia Garza, Patrisse Cullors, and Opal Tometi, who began the hashtag Black Lives movement, which was ignited in response to the acquittal of George Zimmerman, who fatally shot Trayvon Martin. And they attempted to trademark the terminology from this movement. Now, relying upon this history, the USPTO rejected the BLM founders' application. The USPTO gave no weight to the fact that the founders of the BLM movement lodged the application. They didn't care. There was no way for them to prove to prove that we need this application to avoid consumer confusion. So the USPTO's position is not surprising, given that the purpose of trademark registration is to identify a source. Trademarks help consumers identify the goods and services they wish to purchase. It's not about protecting an expression and owning that expression. The function of the trademark is to designate the source of a particular good. With this in mind, the pending application of the White Lives Matter is likely not to be successful. There is no designation to recognize the goods in order to protect the consumers. So I say all of that to say, what I see is them using the mark to limit hateful, what is viewed as hateful or white supremacy speech, but what others believe to be racism. Whatever the view of the slogan, it challenges the First Amendment. Is this speech that should be censored? Do we want to censor this speech, or do we want to attempt to censor, or in the attempt to censor speech, does that lead us down a slippery slope of what we can say and how we can express ourselves, which is the bedrock of American values? If we censor speech, even if we don't agree with what's being said, won't our speech eventually be censored as well because someone will be in disagreement with what we say? Ultimately, more speech leads to more speech, preventing ideologies from either extreme from being silenced, a bedrock of American values and what's core to the democracy that America says that it has. So let me know your thoughts in the comment section. Were you aware of the White Lives Matter trademark, of the other applications that were tried to trademark the phrase? Do you think we are heading down a slippery slope if we try to censor speech, even if we don't agree with the message? Let me know your thoughts in the comments section, and I will see you next time. Oh, don't forget to like and subscribe. Thanks again. Bye-bye.